Hello guys and welcome back to my new video. So in today's video I would be discussing section 21 and 22 of the Specific Relief Act. So let's begin. Power to award compensation in certain cases. In a suit for specific performance of a contract, the plaintiff may also claim compensation for its brief in addition to such performance. This clause by use of the words also and in addition to makes it clear that in a suit for specific performance of a contract, a person can, along with this relief, also claim the relief of compensation or damages. If in any such suit the court decides that specific performance ought not to be granted, there are many cases where specific performance can't be granted, as we have discussed in earlier videos, section 14, 16, section 20, etc. Certain examples. So, if any such circumstance occurs that the specific performance cannot be granted, but that there is a contract between the parties which has been broken by the defendant. Obviously, this sentence was not so needed but good enough to clarify, and that the plaintiff is entitled to compensation for that brief, it shall award him such compensation accordingly. So this clause says that if there has been a suit for specific performance and there was a contract between the parties and the same was breached, then the party who has breached the contract will have to compensate the other party for the same. If in any such suit the court decides that specific performance ought to be granted, but that it is not sufficient to satisfy the justice of the case, there is some such case that even though we have granted the specific performance, but it has been of no practical usage, or it has been so late that it cannot be said that complete justice has been done. So if there is any such circumstance that we can say so, then in such a case compensation would be granted accordingly. I mean, this would be a factor which would be considered by the court for granting compensation, and that some compensation or for breach of contract should also be made to the plaintiff, it shall award him such compensation accordingly. In determining the amount of any compensation awarded under this section, the court shall be guided by the principles specified in section 73 of the Indian Contract Act. So, as I had discussed in my starting videos, that damages or compensation as a remedy are also found or mainly found under the Indian Contract Act. So the entire law or the jurisprudence regarding the same is mentioned in that law. So the principles as enumerated under section 73, 74, 75, etc., though they have mentioned 73, but as a result they will also be applicable in such a circumstance. If compensation has to be calculated at all in such cases of specific performance, then section 73 Contract Act will play a major role. For curiosity purposes, say section 73 makes it clear that we need to check the proximity of the damage done, which could have been imagined or comprehended by the person breaching the contract, etc. So all those conditions mentioned in section 73 will be taken care of while determining the compensation under this section. No compensation shall be awarded under this section unless the plaintiff has claimed such compensation in his plaint. Now this is something which is a matter of common sense for an advocate. Like, courts will grant you what you have asked for in a civil case. When you have not asked for damages, they will just presume that you don't want damages, right? So this is what they have stated. However, there are times when an advocate has made a mistake, or maybe they realized later that damages should be claimed, or whatever the facts and circumstances of the case are. So provided that where the plaintiff has not claimed any such compensation in the plaint, the court shall at any stage of the proceeding, any stage of the proceeding means any time before the pronouncement of judgment, allow him to amend the plaint. Now amendment of plaint is done under Order 6, Rule 17 of the Code of Civil Procedure 1908. So we need to look into that to understand amendment of pleadings, which is a separate topic in itself, on such terms as may be just for including a claim for such compensation. So this proviso says that in case a plaintiff has not claimed compensation and now for whatever reason it wants to claim so, then it can do so via seeking amendment of plaint, and the court may allow, court is under not an obligation to grant the permission, it may allow so looking into the facts and circumstances of the case, and even when it is allowing, it may look into such conditions which might be imposed upon the plaintiff for not having being seeking that particular relief before. So that would be done. Costs might be imposed on the plaintiff. So this term is included here to ensure complete justice in such cases, so that the amendment of plaint at a later stage is of no injustice or of prejudice to the defendant also, and even the plaintiff is given a chance to rectify his or her mistake. So the explanation: the circumstances that the contract has become incapable of specific performance does not preclude the court from exercising the jurisdiction conferred by this section. So this explanation makes it show that even if the contract is found of such nature that it cannot be specifically enforced, maybe it under this law or under any other law, but if compensation is being sought and it is a fit case for the same, then compensation would be given. The fact that it can be enforced or not enforced will play no role hereby. So guys, I had to discuss section 22 in this video also, but I guess the video has got too long. So that would be the subject matter of my next video. And I hope that you have liked my video. You would share it and appreciate my channel, my hard work. And thank you so much.